Welcome. My name is Jason Thomas. On behalf of Deborah Buford, Manager, Employee Accountability and Workforce Relations at the U.S. Office of Personnel Management, it gives me great pleasure to welcome you to today's roundtable entitled Adverse Actions under 5 U.S.C. Chapter 75, an overview. Our office presents roundtables in support of our ongoing effort to bring relevant and reliable developmental opportunities to federal sector employee and labor relations practitioners. Today's presentation will provide an overview of the various elements of an adverse action and the responsibilities of the Merit Systems Protection Board in deciding appeals from an adverse action. We encourage everyone to make the most of this roundtable, including asking questions of our presenter. You may do so by sending an email to employeeaccountability@opm.gov. We will do our best to field as many questions as possible. Please note that shortly following the presentation, everyone who registered will receive a hyperlink to an online evaluation form courtesy of surveymonkey.com. Simply click the link, follow the instructions, and your valuable instant feedback will be sent back to us. Your feedback is important to us and helps us plan future roundtables. We are pleased to have as today's presenter Michael Bogdano from the Merit Systems Protection Board. Mike currently serves in the MSPB's Office of Regional Operations as the Senior Legal Liaison between headquarters and the MSPB's 8 regional and field offices, and as a certified mediator in the MSPB's Mediation Appeals Program. Please join me in welcoming Mr. Bogdano.
Thank you very much, Jason. Good morning or good afternoon, depending on where you guys are. And welcome to a 90-minute version of everything you've always wanted to know about adverse actions, and probably a lot of things that you really didn't want to know about adverse actions, but you'll hear them here. As the title of this session suggests, really this is just a basic overview of all of the kinds of considerations that you should take into account if you're thinking of bringing an adverse action. The board's role, of course, is to adjudicate cases that are appealed to us, but the outcome of a case is pretty well determined well before it gets to us while it's still with you folks. And so if you're representing an agency, these are the kinds of things that you really have to keep in mind in order to try to assure the success of your case. And of course, if you represent an appellant, these are the kinds of things that you want to know in order to be able to refute the agency's case. So, with that said, starting with the basics, what is an adverse action? An adverse action really is defined in both 5 U.S.C. 7502 and 7512 as a suspension, a removal, a reduction in grade, reduction in pay, and a furlough for 30 days or less. Adverse actions, as I say, include 7502 definition, which lists suspensions for less than 15 days, and 7512 lists suspensions for more than 15 days, well, for 15 days or more. And so the question is, why are those two separated? And the answer is simply that a suspension under 7502, the short suspension, is not appealable to the board. So basically, not all adverse actions are appealable to the board. One kind of adverse action that is sort of unique, if you will, because really the issue before the board is only its jurisdiction. The determination on jurisdiction is the determination on the merits in these cases, and that is constructive actions. Constructive actions are actions that appear to be voluntary on the appellant's part, on the employee's part, but the employee claims that he or she was coerced into them or was forced by circumstance or didn't have enough information in order to make an appropriate determination. The kind of thing, in other words, that does look like it was a voluntary separation or a voluntary downgrade, voluntary absence, that the employee says, no, really, I had no choice in that matter. If the action is one that was taken entirely by the employee, but we ultimately determine that the action was involuntary, then we find both that we have jurisdiction because it truly is an adverse action and not a voluntary action. And also, we reverse the action because the employee got no procedural protections with it. I'll talk about procedures a little later, but I just wanted to point out constructive actions because they are somewhat distinct from the rest of the kinds of cases that we have. And so because the difference between those cases is the outcome, I should say, is determined by whether the action is voluntary or not, the question is, how do you know? The case that the board wrote that as the lead case on that issue, Bean versus the Postal Service, which is cited on the slide, basically makes it a two-part test that if you read cases before Bean over the years, it made it sound really pretty complicated as to how you were going to go about proving that this was an involuntary action. But Bean basically boiled it down to a two-part test. Number one is that the employee really was lacking a meaningful choice in the matter. And number two is that the agency's wrongful action is what deprived him of that choice. The kind of case in which Bean arose was one where the employee said, the agency is not accommodating me, my physical disability, and therefore I have to stay away from work. The agency said, you've been away from work on your own, by your own choice there, pal, and we're not, going to do anything for you. The board then applied that test to determine whether or not, in fact, the agency had the agency's wrongful action did, in fact, deprive the employee of a meaningful choice, and it determined in that particular situation that, yeah, the employee should have been given some extra accommodation, and because he wasn't, the action becomes involuntary. There are two real preliminary issues in connection with adverse actions. Number one is who can appeal an adverse action, and number two is what is an adverse action. As I've said, we've talked about what an adverse action is, but who can appeal an adverse action tends to be a little bit more complicated. As this slide indicates, it's 5 U.S.C. 7511 is the answer to who can appeal, but it tends to lead to some complications. The factors that make a difference with respect to that question, that answer it yes or no, are whether the employee is in the competitive service or is he in the accepted service, is he or she a preference eligible, is the employee in a probationary or trial period, and in some instances, does the employee have current continuous service? Those are the factors that determine it, and the way to tell is by applying the test as it's set out in 5 U.S.C. 7511. 7511 defines the term employee specifically for purposes of Chapter 75. You'll see other definitions of the term employee in the U.S. Code, and also in the regulations, other regulations than Part 752. But specifically for purposes of an adverse action, it's 5 U.S.C. 7511 that you need to look to. It sets the specific rules for finding jurisdiction. if you read through 7511, what you'll see is that an employee means an individual in the competitive service who isn't serving a probationary or trial period under an initial appointment, or, and then it says, except as provided in Section 1599E, which is a Department of Defense regulation, person who's completed 1 year of current continuous service in other than a temporary appointment. The limitations for people in the competitive service are relatively few. It's just that. I should say that for a person in the accepted service, the test gets a little harder, but not tremendously if they're a preference eligible, because the preference eligible in the accepted service also has to complete 1 year of current continuous service in the same or similar positions in an executive agency or in the U.S. Postal Service or Postal Regulatory Commission. So it is just a slightly higher burden. But then subpart C of 7511 goes on and talks about the accepted service non-preference eligible. For those people, the two tests are set out there. Person isn't serving a probationary or trial period under an initial appointment, which is pretty much the same as was required in the other two cases. And then the other test, though, is if the person has completed 2 years of current continuous service in the same or similar positions in an executive agency under other than a temporary appointment. And I'm sorry, I actually should have put that footnote about what 10 U.S.C. 1599 means on the prior slide, but 10 U.S.C. 1599, for those of you in the DOD know, sets a 2-year probationary requirement for all DOD employees, at the moment at least. In most other instances, it's only a single year. But, given the talk of civil service reform, it's entirely likely, it seems to me, that we may be seeing some changes to 7511 in the future. For now, however, that is the rule. The difference between whether you're preference eligible or not is a major point in determining who has and who doesn't have adverse action appeal rights. Most of the time, people will say, well, a preference eligible means a veteran. And generally that is true, but it isn't entirely true that there's a total agreement between preference eligible status and veteran status. So if you want to be sure about whether somebody is going to have adverse action appeal rights, you need to look up the definition of preference eligible in 5 U.S.C. 2108. And whether it's intuitive or not, you'll see that there's a 2-page definition of what constitutes preference eligibility. So that alone is a fairly significant kind of impediment to board appeal rights, but it's a fact that we have to consider and that you too have to consider if you want to determine whether somebody has appeal rights. As I say, the determination of who has appeal rights is done on the basis of 7511 and in that sort of order of difficulty from competitive service to accepted service preference eligible to accepted service non-preference eligible. And just for your information, up until, 30 years ago or so, accepted service people really did not have appeal rights to the board, and so from an adverse action. So despite the fact that it's harder to get appeal rights if you're in the accepted service, it is easier now than it used to be. One of the cases that I wanted to mention is the most recent case that the board issued on the meaning of 7511. It's a case called Wins versus the Postal Service, and it overrules years' worth of precedent that, in my mind, was very equitable, but contrary to the statute. In a case called Roden versus TVA, the appellant had been appointed to 5 consecutive temporary appointments in the same position, separated by brief breaks in service. And if you go back to the 7511 definition, breaks in service and term appointments, or temporary appointments rather, mean that you don't meet the definition of employee. But the board said that it should really consider substance over form, and the fact that the guy kept being hired for, this 5-year period, and only had short breaks in service between those appointments signified that the agency really was treating him like an employee and was trying to just get around the rules. And so they found that there was an appeal right in that instance. The board in last year held to the contrary, that they really did have to enforce the statute, and since the statute says no, the rule is that if you have one of those impediments, such as a temporary appointment, even if it's renewed several times, we're going to treat that under the statute and say the person is not an employee for purposes of appeal rights. Still, I would caution agencies not to do those kinds of appointments that really do look like they're intended to hurt the person rather than treating the appointment as is appropriate. The other aspect of 7511 that I mentioned, what that was really significant, is probation. A person who is a probationer does not have an appeal right to the board under 7511 as an employee, and their only appeal right comes under 5 U.S.C. Part 315. That appeal right, however, does not give the board the authority to examine the merits of the reason for the employee's termination. What it does is say that if the employee can prove that the termination was due to partisan political reasons or marital status, or was based on pre-appointment reasons, then we can look beyond that and consider a claim of discrimination, Title VII type discrimination, or ADEA or ADA discrimination. But nothing in that chapter gives us the authority to examine the merits of the case itself. And when I say that you have the right, if you can prove that your removal was due to partisan political reasons, the board has defined partisan political reasons to mean your association with a specific political party. It does not mean simply that you tend to be conservative, you tend to be liberal, you tend to be an independent. It has to be affiliation with a specific political party. And when it says marital status, that means, are you married, or are you not married, or are you divorced? But it does not mean those things that go with that status. Frequently what we end up hearing is, well, I'm a single mother and I have 2 kids, and I had to take them to school, and that's why I was late, and that's why I was fired. And that, unfortunately, is not marital status discrimination. It is simply on the effect of marital status, perhaps, but it's not marital status itself. So that's really the only rule. And I should say because Part 315 applies only to the competitive service, we do not, well, if you're in the accepted service and a probationer or on a trial period, we don't have jurisdiction over those cases. So it's only probationers who get that limited jurisdiction. With respect to pre-appointment reasons, if an agency has terminated somebody in whole or in part because of pre-appointment reasons, quite frequently what that means is something they wrote on their SF-86 or their application for the job or something that turns out not to be true in the agency's view. If that is the fact, then the only issue we examine is whether the agency gave the employee all of the procedural rights that are in 315-806. Other than that, however, all we can look at, as I say, is a claim of discrimination. Of course, we can reverse the action without looking at the merits if we find discrimination or if we find that the employee didn't get the procedural protections he's entitled to. Excuse me, there are rules for crediting prior service and time in an absence status and part-time service towards completion of a probationary period. And of course, that makes a big difference because, as I said, probationers don't have the rights of an employee as a general rule. But those factors can give somebody who is otherwise a probationer the rights of an employee. That sounds kind of dissonant and weird, but basically what it means is that even if you're in probation, if immediately prior to the appointment, the probationary appointment, the employee completed a 1 year of current continuous service without a break in service of a work day between the old job and the new job, that is going to make him, that's going to allow him to say, I completed my probationary period and get the same rights as an employee. You can be credited with prior service. If you're looking toward the accepted service, what you'd have to prove is those requirements of 7511C if you're not a preference eligible. And so you'd have to prove that that prior service was in the same or similar position, as well as being, as well as having been current and continuous. So even when you get the benefit of the tacking, as it's called, of prior service or the completion of a probationary period based on current and service without a break of a day, you still have to meet the other requirements for being an employee, depending on whether you're in the competitive service or the accepted service, and whether you're preference eligible or not if you're in the accepted service. So, I mean, I think the point of that is just as complicated as 7511 is on its face, it's actually even more complicated when you come down to applying it with these additional exceptions and additions that come with the Chapter 315. Anyway, that really is the difference between who can appeal and who can't appeal. In other words, it takes some study to determine what happens. I mean, if somebody's a probationer in their first federal appointment, they're always going to be a probationer, and they're not going to have appeal rights. Excuse me, but if you're dealing with somebody who's come to your agency from someplace else or come from a different branch of your agency or something, that's where you're going to have to be more careful with respect to whether the person has employee rights. So now that we've gone through what can be appealed and who can appeal it, which are the two big jurisdictional issues in an adverse action, we get to the merits. And the first thing that I thought we should talk about is the burden of proof in an adverse action. Who has it, what is it, and by what degree of proof? And the answer to that has been the same for many, many years, which is that the agency has the burden of proof because it's the party that brought the action, and it has the burden of proof as to three things. Number one is the charges, number two is Nexus, and number three is the reasonableness of the penalty. Proof of the charges and proof of Nexus have to be by preponderant evidence, and the board's defined preponderant evidence in its regulations as the degree of relevant evidence that a reasonable person considering the record as a whole would accept as sufficient to find that a contested fact is more likely to be true than untrue. So more likely than not, this is true. Generally, people will say, sort of offhandedly, that means 51% of the evidence. And sometimes that's true, but it isn't true because of the fact, in some instances, I should say, because of the fact that you have to consider not just the amount of evidence that's available, but its persuasive value, its credibility, its materiality, its relevance. All of the things that make evidence persuasive or not go into that determination. So it's not simply, well, I can make a list of 10 things that support my action and only 5 that don't, and so I win. It's really a question of the credibility and weight of the evidence. And that's a determination that the board makes, of course, on appeal, but there are a bunch of things that an agency can do while the case is still within its control that will help determine that outcome. And the first biggie, and related to the burden of proof, of course, is the charges. The title here on this particular slide is Be Sure or Start Over. And I find that to be true in a huge number of cases. If you don't pick the right charge, that is a charge that you can prove and a charge that the evidence supports, and also to a slightly lesser extent, if you don't write it up correctly, you're just never going to be able to win your case. So you have to start from the beginning with charges and be sure that you choose the right one. The board generally says that there are 3 overall categories of charge, the way that a charge can be written. Number 1, descriptive or specific charge is, as the name suggests, you're charged with absence without leave. That's a specific charge, and then you go on and describe what it was, what supports that. Number 2 is a generic charge. A generic charge is one that really does not mean very much alone and depends on the specification in order to give it some meaning. generic charge is most commonly conduct unbecoming a federal employee. However, I gotta say, after having done this work for so many years, based on the kinds of charges that we've seen, I don't think there's any conduct that's unbecoming a federal employee, because we've seen it all. But in any event, conduct unbecoming, inappropriate conduct, that kind of thing that needs more information to make it meaningful is a generic charge. A narrative charge is one that does not have a title, simply says, here's what happened. There are advantages and disadvantages to each of those kinds of charges. You definitely need to consider which one you want to use, which type you want to use when you write a letter of charges. The thing about narrative charges is that because they don't tend to say, and so here's what you did wrong in any easily chunked portion of the narrative, somebody has to make the determination of what the charge is, and that somebody is going to be the judge in your case, which will take away from you the authority to determine what that charge is. So if you're going to use a narrative charge, you might want to be a bit more careful in specifying what it is. We'll frequently see charges that go on literally for 3 or 4 pages of single-space type, and when you get to the end of it, you say, the agency didn't like what the appellant did, but I'm not quite sure what that was. So really, it does take some effort to make sure you're being specific enough. There are, again, 3 parts of a charge. The label, which is obvious, and as I say, we don't have to have a label, but if there is one, it's significant, as we'll say in a few moments here. The specification, which is simply the specifics of what that charge relates to. And then number 3, the legal elements. You obviously don't have to put the legal elements in the charge. Some agencies do, but those elements are what you're going to have to prove. So putting it in the charge in a way makes it easier for the agency to assure itself that, in fact, it can prove that charge. Writing a charge up after you've chosen what it is can be more complicated than it seems. And on this slide, I've listed some of the common charging issues or errors that come up. Splitting charges is something that is really easy to fall into. What this case, Burroughs versus Department of the Army, stood for was that you can't split a charge. In that particular case, Mr. Burroughs had been charged with, quote, directing the unauthorized use of government property for other than official purposes. Well, clearly you got an unauthorized use and an unofficial purpose, or other than official purpose, in that charge. And the board reviewed it and said, well, he actually did act without authorization, so that part of the charge is sustained, but he did it for an official purpose, so that part of the charge isn't. And then the board went on and sustained the removal based on that half of the charge. And the court said, no, you cannot split a single charge. Unfortunately, it's not always easy to tell if a charge is one thing or 2 things or 3, but in this case, it was clearly a single charge of, using the property for other than an official purpose. So that one has been the rule for, the last 30-some years or 20-some years. It is just one thing that you really need to consider. I mean, granted, it's the board that ends up splitting the charge if it comes down to it, but it's something that you have to keep in mind when you charge something, so that you'll want to be clear about it. Merger of charges is significant because frequently what happens is something goes wrong that the employee is accountable for, and the agency then looks at that and draws up 6 charges from the same exact thing. And if they're based on factual differences, if they're based on legal differences, that's perfectly fine. But if proof of one of those things proves anything else without the need for additional evidence, then we will merge those charges. And so you don't end up with 6 charges, which makes it look like, oh boy, this appellant is beyond redemption. You may end up with only 1 charge or 2. But again, it's something to keep in mind as you're writing charges. Multiple specifications under a single charge, that's where the agencies get a break. If you put a label on a charge and then you list, for instance, AWOL, and then the specification says you were AWOL on day 1, day 2, day 3, et cetera, even if the agency only proves, yes, he was AWOL on day 1, but not on all of those other days, we sustain that charge. So again, it's consideration for how you write your charge. And the last on this slide is that the charge doesn't match the specification or the narrative. This is significant in connection with something I'll be discussing in just a couple of minutes about which charge to choose, because if you charge somebody with a crime, for instance, you have to prove the elements of that crime. If you've charged them with something that is a crime, and the only thing that you prove is something less than a crime, then you haven't proven your charge. And if you haven't proven your charge, it's not sustained. And if that's the only charge, then the action won't be sustained at all. Obviously, if it's only one of the charges, then that makes a big difference, and we may be able to sustain the removal or not. But in any event, that's something the agency always has to be very careful of. Next, independent elements of a single charge. This is where it gets kind of hairy to make a determination. For instance, in this Fairley case, the agency charged the employee with striking a coworker and threatening her with physical harm. And that was the way the sentence was written, as a single charge. The board in that case was willing to find that those are really 2 independent acts, and therefore we can look at them as independent acts. Unlike the Burroughs case that I mentioned before about splitting charges, these were clearly 2 different things, while in Burroughs it was 1 act that was wrongful in 2 ways. And the court and the board found that to be a significant distinction. Lesser included offenses, that's a term that's used in the law that determines whether, for instance, in a capital murder case, if the agency doesn't meet its burden of proving murder, but the evidence does prove manslaughter or some other form of unlawful killing, then in a lot of cases in the law, the court can find you guilty of that lesser included offense. The board, however, has determined that we do not find somebody guilty of an offense with which he was not charged, and therefore if you charge something that has elements that you cannot prove, but you seem to think, well, yeah, but I could prove a sort of lesser version of that. That's not going to work. So you may want to be pretty careful about it when you state what your charge is. And last here is criminal offenses. And as I've suggested, the big deal about a criminal offense charge is that you have to prove the criminal offense. And in the law, every crime has specific elements of proof. So if you're going to charge somebody with theft, if you're going to charge somebody with murder, if you're going to charge any kind of a criminal offense, you have to make sure you know what that criminal offense is. Most criminal offenses are matters of state law. If there is no federal definition, then that's the definition that you have to meet in the state where the action took place, whatever it was. That's one of the disadvantages, I guess, of charging a crime, but we do see it a good bit. Next, the idea of loaded words. This is a particularly good way for an agency to make its life a lot harder than it absolutely has to be. Words that imply intentionality, some intentional misconduct, require the agency to prove that the employee intended to do something. If you say you did it knowingly, you did it willfully, you did it intentionally, any of those things indicating volition on the part of the employee and an intent to do it will require you to prove that. I used the word threatened here because it too is a loaded word in a slightly different way. It's loaded because it has a specific meaning in board law as decided by the Federal Circuit, and we'll get to that in a minute. But it's one of those loaded terms that you might want to consider either being totally certain that you can prove it or avoid using it. Obviously, the trade-off tends to be that if somebody does something intentionally, it is more of an offense, and therefore the likelihood is that you're going to find a harsher penalty is appropriate. If that is not intentional, then that's the kind of thing that may lead to a lesser penalty. It just depends on what the conduct was. And finally, on this one, that last sentence is what the board looks at, the structure and language of the proposal notice in order to decide how to construe the charges. And then, as I say, when you do charge something intentional, as intentional misconduct, you can either do it by saying you did X intentionally, or you may not realize it, but by picking one of these 4 charges that are listed on this particular charge, you have given yourself the requirement to prove intent, whether you recognize it or not. You can't get inside somebody's head to know what they were really thinking, so it's harder to prove intent. But as the Riggins case at the top said, intent is a state of mind, and it's generally proven by circumstantial evidence. Circumstantial evidence, as the name implies, is just evidence that appears from the circumstances to be a reasonable conclusion based on what has gone on. These 4 examples are ones that we commonly see. Theft is the intent to deprive the owner permanently of the possession and use of his property. Frequently, not frequently, but from time to time, what we'll see is an agency charging theft. The employee took a drill from the agency's tool room, and that's theft. If the employee comes in on appeal and says, yeah, I took it and I shouldn't have done that, but I was going to return it as soon as I was finished with this project I'm working on at home, and if the board agrees that, yeah, he's credible in saying that, then you haven't proven theft because he hasn't intended to deprive you permanently of your use of the drill. So you might, if that's what he tells you in response to the charge, the proposal, you might consider using something other than theft, like unauthorized possession. Again, with threat, that the METS test is what applies. The board and the court apply a reasonable person test and apply it to the reaction of the listener, his or her apprehension of harm, the speaker's intent, the circumstances, and whether it was conditional. Frequently what we see is somebody who just gets really upset and said, if I had a gun, I would kill you, that kind of thing. And if the agency charges threat and the board finds, well, he was really just upset, this was a conditional threat because he didn't have a gun, you didn't react to it the way you would if you really thought he was going to kill you, then you haven't proven threat. If you charge something else, like inappropriate conduct that caused concern among your coworkers, that might be an easier thing to prove. In other words, just keep in mind the constraints that you're putting on yourself when you choose a charge. Insubordination is willful and intentional refusal to obey an authorized order of a superior officer that the officer is entitled to have obeyed. That is the definition that has applied for years now. You can't simply prove that somebody didn't do what you said to do as his supervisor. You have to prove that they willfully and intentionally did that. I cited to the Follow the Rules Act of 2017, excuse me, which is an act that directly affects whistleblowers, and it makes a prohibited personnel practice out of taking an action against somebody for refusing to obey an order that would make him violate a law, rule, or regulation. The way the statute had originally been written said only that it would make him violate a law. The case that came up in the Federal Circuit, the employee violated a regulation. The employee argued that he would have had to violate a regulation if he followed his supervisor's direction. The court said, sorry, this says law, it doesn't say regulation, so it wasn't a prohibited personnel practice for the agency to take action against you for that. Congress got word of that, and within about a year and a half said, we're changing the law here, folks. And so now law, rule, or regulation is what is in the statute. But anyway, the point is that in insubordination, if that's the charge, you do have to prove willfulness. And falsification also, providing incorrect information is not going to be enough. It has to be accompanied by the intent to defraud, deceive, or mislead the agency. And that had been the definition for a good 20 years. And then a case called Leatherbury versus Department of the Army came along, and the court kind of played with that definition and said, not only do you have to prove the intent to defraud, but that has to be for the employee's own private material gain. It doesn't have to be financial gain, it just has to be some sort of gain. And in that particular case, excuse me, the agency didn't meet the burden of that proof on that particular aspect of the case. So those are things that you have to consider. The cases that are listed here have elements of proof, but they don't require a proof of intent. So it is a lesser burden of proof for the agency, but you do have to be sure you know what those elements are. Misuse of a government property is as defined by Section 2635, which are the ethics regulations. AWOL is defined in the way set out there, not simply that the employee was absent, but the absence wasn't authorized, that a leave request was properly denied, that kind of thing. Failure to follow leave requesting procedures is a separate charge from AWOL. You have to prove that the agency has those procedures, that the employee knew what they were, and that he or she failed to follow them. Failure to follow instructions, that is basically insubordination light. That's the kind of charge that you want to use if you don't think you can prove insubordination. Unauthorized use of a government vehicle, if you charge that specifically under 31 U.S.C. 1349, which requires at least a 30-day suspension, then you have to prove that the employee acted willfully or with reckless disregard, whereas if you simply charge under your own agency policy or use different terminology, you can have a lower burden of proof. Lack of candor, that is, in my view, sort of falsification light. That's the lesser burden to prove that what somebody said was not correct or not complete. Lacking candor in most cases really does mean, well, you gave us part of the story, but you left out some of the stuff that's really incriminating, and so you lacked candor. That charge had always been pretty straightforward, but these two cases that are listed at the end, Farnioli and Oleg, make it a little less clear just how to prove lack of candor. But if you read those two, that is really what you need to do before you decide that that's the appropriate charge. Sexual harassment, again, another charge where there's a statutory definition under Title VII, and those are the requirements you have to meet set out on the slide if you're charging sexual harassment. If you charge sexual harassment under your own agency policy or call it something else, then, again, you can have a different burden of proof or a lesser burden of proof, such as, for instance, this creation of a hostile work environment. That, too, has a a definition that's well established in discrimination case law. But if you call it something else, that it will get you around it. And then approved leave. Agencies frequently want to be nice to their employees, and if the employee is going to be out for a long time, the agency may very well say, okay, we'll give you annual leave, we'll give you sick leave, we'll give you leave without pay. And before you know it, the person's not been there for a year, and the agency really needs to have that job filled. They can't do that if they've approved leave, so in some instances, the agency really has to not be Mr. Nice Guy and start denying leave, and the employee goes on AWOL. There are exceptions to that are set out there, but I'd better move along because I don't want to end up only halfway through this outline. The second aspect of the agency's burden of proof is a nexus. The rule is that an agency may take an adverse action only for such cause as will promote the efficiency of the service. That wording has been the law since the 1912 Lloyd-La Follette Act that really changed the civil service. What it means is that there has to be a nexus or a connection between whatever you're charging the employee with and taking an action for promoting the efficiency of the service. You could charge somebody with, you're wearing a striped shirt today, Bogdano. Yeah, you're right. You could prove that charge, but unless you can tell me why that's wrong, there's no nexus. And so that's the kind of thing that it is intended to address. Proof of nexus, the board has always held that there are three ways to do that. Number one is that there's a rebuttable presumption. And remember the term rebuttable. It means that the agency's, even if the agency gets the presumption, the employee can try to rebut it. That applies in egregious circumstances, child pornography, murder, anything that's, generally considered a pretty heinous kind of thing. The number two is you can introduce preponderant evidence that the misconduct adversely affects the employee or his coworker's job performance or the agency's trust and confidence in his job performance. That's a biggie. That's really what we tend to see the most, and that's a matter that the agency simply has to prove. The agency gets to determine whether it has lost trust and confidence in the employee, but there are factors that affect that, and we'll be talking about those in connection with the penalty. And the last way is preponderant evidence that the misconduct interfered with or adversely affected the agency's mission. And that Kruger case is the one that sets all of that out. Three easy examples of these. In Graham, the guy was charged with sexual abuse of a 14-year-old girl. The board said there's a rebuttable presumption there because that's terrible misconduct, egregious. In Doe, Mr. Doe was an FBI employee who was charged with videotaping his sexual encounters with two of his coworkers. Mr. Doe simply did the videotaping without telling these women that, but did not introduce any of the videotapes to the office or anything of that sort. One of the women found out about them, the other woman, and as a result, it was they who got together and started messing up things in the office, pointing to what terrible conduct this guy had for sleeping with both of them. And it became the talk of the town, obviously. And the issue was, is there a nexus when the guy only made these films for his own private enjoyment, and it wasn't his fault that it, in today's terms, went viral in the office? And the board said, yes, it was his fault because he was the one who provided the incentive for all of that to happen. Finally is an example of agency mission. A guy who worked for HUD, the Housing and Urban Development Agency, was a slumlord. And for that, the board said, yeah, there's no way that the agency can't charge him with that. So moving on, the third, I should say, nexus is not generally a problem. In most cases, it's pretty obvious. But if you think in your situation that based on your charge, it's not, then you have to be pretty clear in why it is important to your agency that this happen. Obviously, if you work for the Postal Service and you've stolen the mail, if you work for the IRS and you've cheated on your taxes, that's pretty clear. But do let the board know what it is that you're relying on for proof of nexus. The Douglas factors. Douglas is no doubt the most cited case in board history with respect to adverse actions. It sets forth a list of 12 non-exhaustive factors that are to be considered by an agency and, by extension, the board in determining whether a penalty is reasonable. And remember, I said the other two factors, parts of the burden of proof, have to be proven by preponderant evidence. The penalty simply has to be reasonable. What the Douglas test is set out on this chart, on this screen. Really, the board gives deference to the agency, and so read that test to know what it is that you have to do. The factor number one, which is the most significant factor, is the seriousness of the offense. Obviously, there are things that make it that are serious in the board's view. Those cases that the board has said are serious involve insubordination, falsification, AWOL, assault, and drugs. The board has been pretty clear on not mitigating drug-related cases in pretty much every instance. So those are the kinds of cases that we have said are serious, but of course, circumstances dictate whether other charges are serious as well. Some factors that affect that: the delay in taking action. If you say the employee can't be trusted and we don't want him around, but it takes you a year and a half to fire him, and that's going to take away from the persuasiveness of your claim. If the employee has done this same thing before, clearly that adds to the seriousness. If the matter turns out to be really just poor judgment on the employee's part, that also goes in his favor. So those are some considerations with respect to seriousness. The nature of the employee's job is also a biggie. It's fairly self-explanatory. We apply a higher standard to law enforcement officers, to supervisors, including informal supervisors, to people in a fiduciary position or a job that requires contact with the public. And also, even if it doesn't require contact with the public, if you're the head of the office, you have a prominent kind of position, we're less likely to give you some slack on the penalty. But it is not true at the opposite end that just because you may occupy a lower level position will excuse that because of if your conduct is sufficiently egregious. The big example of this is one I'll talk about in a moment. But moving on to factor 3, prior discipline. There's a case called Bowling versus Department of the Air Force, which says if you've been disciplined in the past, we will not reconsider the propriety of that discipline if the agency meets the agency's action at the time met these 3 requirements. We will only review it to see if we think it was clearly erroneous. And we define clearly erroneous in this circumstance as a definite and firm conviction that a mistake has been committed. So it's a really high burden of proof where the agency has met this requirement. USPS versus Gregory is one of a bunch of cases that have gone to the Supreme Court. The Federal Circuit, which is our main reviewing court, had previously said that the agency can't rely on pending grievances, any kind of discipline that is being challenged. And the court ultimately disagreed with the Federal Circuit and upheld the board's decision. That being said, what you have to consider, of course, is that if you rely on a piece of past, on a challenged action as prior discipline, and in that mode of the challenge in the grievance or the EEO complaint, your case is upheld and the discipline is reversed, that will, of course, have some effect on the board's determination, but you can go ahead and use it. Stale discipline, there's no absolute rule for when something is stale, but that's frequently set out in a collective bargaining agreement or in an agency regulation. But even if something is stale as discipline, you can use it to show that the employee was on notice. Past work record. The biggest mistake that we see in connection with this is the agency gets up on the stand and the supervisor says, the employee's been here for 10 years. He should have known better than to do that. And what the board says is that when you put it that way, you're making long service an exacerbating factor rather than a mitigating factor, and long service is in fact mitigating. It's okay to say the employee knew the rules, and it's okay to consider that he worked there for 10 years, and that's the latter is a good thing and the former is an important factor in the agency's behalf. But you just really have to be careful about how you say that. If the past work record reflects poor performance, if it's an aggravating factor, it has to be in the proposal in order to rely on it for the removal or suspension or whatever. And in some cases, what we'll end up seeing is somebody has an outstanding performance evaluation, and in the notice of proposed adverse action, the agency will say, yeah, and we really haven't been crazy about your performance either. Clearly, that is going to cause some problems. So just be careful about that kind of thing. Trust, again, this is the loss of trust by the agency. And while it is true that the board is willing to give the agency a lot of deference, this Jackson case that's cited there, the employee was a meat cutter, and the decision letter said, you occupy a position of trust as a meat cutter, and that's why we're firing you for whatever it was you did. And the board said, no, that goes too far. So, generally speaking, that's fine, but not with respect to some lesser kinds of positions. The consistency of the penalty. This is an interesting topic because for purposes of disparate penalties, which means just your basic adverse action case, the test is different than it is for purposes of disparate treatment, which means a case in which a claim of discrimination has been made. The disparate penalty case, you would think, might have an easier burden of proof because it doesn't involve a claim of discrimination, but that isn't actually true. The Lewis case sets out the board's thinking on this, which is basically that there have to be circumstances that are very similar between your case and that of a comparator to whom you want to say, whom you want to argue was treated better, but the board doesn't have any hard and fast rules about that. And so when you're looking for discovery when the employee is looking for discovery during an appeal, the right he has to getting comparator evidence is broader now than it used to be. Table of penalties is really not a very important kind of factor, and frequently we'll see a charge that's listed in the table of penalties with a recommendation of a penalty from reprimand to removal. And if that's all it says, it's worth nothing. So be careful about what you put in your table of penalties. And if you do want it to be binding, you have to say that, because otherwise it's generally not. The notoriety of the defense. Obviously, if there's been a newspaper article about whatever it was you did, introduce that to prove that that is something that was significant. But I cited the Wilbur versus Treasury here to show that it's not simply newspapers, radio, television. Unfortunately, Mr. Wilbur was driving drunk one evening and got into a car accident, and sadly, a 2-year-old died as a result. And Mothers Against Drunk Driving, MAD, found out about this and used it in their fundraising efforts, and that was one of the factors that the agency was able to rely on. So notoriety can be any type of notoriety. And then again, with something like the Postal Service, the term going postal had been reasonably common at some points, and so, to the extent that that is a concern, the board has allowed reliance on that. Prior notice, clearly agencies, policies, agency rules, whether they are in fact the law or whether they are in fact required, as long as you're on notice of them, that's really what counts. There are some things that are commonsensical, and you don't need to be told that you shouldn't do that. Farrell was an employee who published a very clever but very cutting, sarcastic, allegedly fictional story involving all of his coworkers that he said really did cover whatever they had been doing. And the board said, yeah, there's no rule that says you can't do this, but come on, we're finding that that's an appropriate charge and it's proper to discipline somebody for that. Length of service, as I said before, can go into the question of prior notice. And even if something is stale, as I mentioned, as prior discipline, it is prior notice. Rehabilitation potential, it's really a hard thing to determine. It frequently tends to be based on whether the employee owned up to his misconduct. And those are some of the sort of common sense rules with respect to that. Clearly, if the employee always has the right to defend himself, but if when he gets up on the stand, he makes up additional facts or something like that, the board is not going to consider that appropriate and will find rehab potential is low. Mitigating circumstances, pretty much everything can be a mitigating circumstance depending on the case, the facts of the case. If whether they are related to your job or not, if your wife is dying, or if you've just had a series of terrible misfortunes in your family, those are the kinds of things that the board will consider. And the Zazweta and Barry case, I put those in simply, as I said, because the board rarely does mitigate drug-related cases, and those are two where the employee introduced mitigating circumstances, but the board didn't buy it. And finally, factor number 12 is alternative sanctions. This one you have to be careful about. You can't use discipline against an employee in order to send a message to the other employees, because each penalty has to be tailored to the offense. But you don't normally, I should say, have to prove that a lesser penalty would have been ineffective, simply because the agency's burden is only to be reasonable. You have to simply show why this one was reasonable, and by analogy, why doing something else wouldn't be sufficient. But it's not generally going to be fatal to the agency's action. And the last thing on this one is the zero tolerance policy does not mean you have to fire somebody. Zero tolerance policy just means you have to impose some sort of sanction, but the sanction has to be appropriate to the charge and the situation in which it arose. So keep that in mind. These are just generally my idea of the top 4 Douglas factors. There are others that you could put in there, but it is, those are among the more significant ones. Procedural requirements are these. They're easy enough to do. They are subject to a harmful error test, and the board defines it as something that would have caused substantial harm or prejudice to the employee's rights. And if you only have a procedural error, that will not necessarily lead to reversal unless it is harmful. But the employee then has to prove that the error was harmful. But it's not quite as simple as that because of this concept called due process. Due process, as the last part of this says, the root requirement is that an individual be given an opportunity for a hearing before he is deprived of any significant property interest. In federal employment, tenure gives an employee a property right in his employment. That is, if you're not a probationer, if you are an employee, you have the right to due process. What does due process mean? Cleveland Board of Education versus Loudermill, obviously related to a state employee, a city employee, rather than a federal employee, but the determination of what it meant for public employees overall is the law by which we go. It's that 3-part entitlement requires a tenured public employee. He's entitled to 3 things: oral or written notice of the charges, an explanation of the employer's evidence, and an opportunity to present his side of the story. That is the basic requirement of the process that I listed there from 7513. That's the basic intent of that process. And it's not generally much at issue in connection with what's in the proposal. Moving on, though, what due process requires is, as I say, this hearing, which is not really a hearing. It is simply the opportunity to present your side of the case. That is, you can argue the facts, you can argue the appropriateness of the penalty, you can even just throw yourself on the agency's mercy, but it's simply an opportunity to put your version of events before the deciding official prior to a decision. And the importance of due process is that, number one, the board can raise it at any time in its proceedings, even if the employee doesn't. And most significantly, if due process right is violated, the employee is entitled to an entirely new, constitutionally correct removal proceeding. Due process is, of course, based on the Fifth Amendment to the Constitution, and so whether you find it was harmful or not does not matter. If somebody was deprived of due process, the action gets reversed. And again, that's not usually a problem with what does the notice of proposed removal say versus what the decision says. Where that frequently has become a problem is in connection with ex parte communications. Ex parte communications are what has tripped up agencies for the last number of years, and it is an ex parte communication is simply a communication Sorry. Thank you. Sorry if there was some microphone difficulty there. Anyway, the ex parte communications that get somebody in trouble are frequently really well-intentioned. I mean, you'll get a deciding official who looks at the charges, hears the employee's response, and thinks, well, I really need more information. I'll have to go out and investigate this. He or she does, and what happens is they reach a determination that, yeah, the appellant really is guilty, and in doing that, they consider those things they heard that they did not tell the employee about, and that is what gets the agency into trouble because they've then violated his right to due process. The Stone case that's on this slide is one of the leading cases on that. And this slide talks about what the test is, a three-part test, whether the ex parte communication introduces cumulative or new evidence, whether the employee knew of the error and had a chance to rebut it, and whether the ex parte communications were of the type that was likely to be to cause undue pressure on the deciding official. That's why ex parte communications are a big problem, and these cases illustrate that. Ward is really the other big case, and I think it's sort of subsumed in some of these others. In Ward, that was found to be a due process violation. Blank versus Department of the Army, the guy was removed on 2 charges. He disputed the charges, and he raised a claim of discrimination and hostile work environment to the agency. I'm sorry, I said on appeal here. That is incorrect. To the agency, he raised it. The deciding official interviewed some people about that and determined that there was no merit to the appellant's claim. Well, that sounds kind of like a due process violation, but the court ultimately held that it wasn't, because the information that the employee obtained was really just cumulative. That the documentary evidence in the proposal notice. So not every ex parte communication is a problem. However, some are, and the Young case shows that. In that case, the employee was charged with shouting insults at a witness during a recess in one of his arbitration hearings. The deciding official went and spoke with not just the appellant and not just the witness, but also somebody the appellant said was there and could vouch for him. That person said, yeah, I didn't hear that the appellant yelled at this guy at all, but of course, I actually left after a couple of minutes, and so I wasn't really there for most of the time. The deciding official considered it and said, the appellant can't rely on this guy because he wasn't really there. And so the question was this clarifying what the appellant was saying or not? And the board and the court ultimately found that this was a violation. It wasn't cumulative because the deciding official himself said that it was a huge departure from the written arguments that the employee had made. I want to cover Lopez because Lopez is significant in that the employee had been removed for something and the deciding official knew that he had a prior 3-day suspension, was aware of other prior actions things against him that he had done for which he hadn't been disciplined, but he didn't inform the appellant of that. On appeal, the agency argued, well, hey, that's not a due process problem because it's not an ex parte communication. The deciding official knew all of this. But the board held that, indeed, personal knowledge of the deciding official may violate due process without any communication. And the rest of the slide there just gives you the rationale for that. Norris was another case where the deciding official said, knew something that wasn't in the charges, and she testified, well, yeah, I knew that, but I didn't consider it. And so the board found that that was an ex parte, excuse me, the case went to the court, and the court found that the employee, the deciding official, was credible and believed her when she said she didn't consider it, and therefore it found that that was not an ex parte communication that was prohibited, that destroyed due process, because it was because the deciding official did not consider it. It still, of course, was ex parte, but they didn't consider it. The Wilson case is really very much like the others, where their board did not find a violation because the appellant had raised the issue in her reply to the proposal, and she actually addressed it repeatedly in discussions with the agency. So the board found, and the court agreed later on, that it was simply cumulative evidence. The last case is one that you should be on the lookout for, FEA versus DOD. There was a case involving a teacher who was removed after her third-level supervisor found out about the misconduct, the alleged misconduct, and said, we really need to do something about this. And the court issued its decision finding that that was a due process violation, even though it occurred prior to the proposal. There was a very strongly worded dissent, and the court ultimately agreed to rehear the case en banc, meaning every member of the court. So those are that's the kind of case that you really need to look out for. Finally, the next slide talks about some of the lessons from this set of due process cases, and I will not go over that in order to save just a second here for the last. How does the agency get around all of this? It's really quite simple. Because the problem is that the employee was removed or had an adverse action based on information that he was not given, give the employee that information, give him an opportunity to respond to it, and then make your decision, and the problem goes away. So that is it, and I recognize that I've gone kind of over here, so if you have any questions, you're welcome to send them in, and I'll try and answer them, send back to OPM, and otherwise, thank you so much for your time.
Right. Well, Mike, thank you, and on behalf of Accountability and Workforce Relations, we appreciate your expertise during today's roundtable on adverse actions under 5 U.S.C. Chapter 75. Your presentation provided an outstanding and informational commentary on the various elements of an adverse action and appeals before the board. I want to thank OPM's communications staff for your webcast of the roundtable. Thank you to my colleagues in Accountability and Workforce Relations for your work on this roundtable. Thank you for participating today, although as Mike mentioned, we will be able to get back to you on any individual emails that come in with questions from today's roundtable. Finally, please remember that shortly you will receive an email with a hyperlink to an online evaluation form courtesy of surveymonkey.com. Your feedback helps us plan future roundtables, and we very much appreciate your taking the time to complete this survey. Have a great afternoon.